Good morning, Justice Knight, Justice Blimke, and Justice Deacon. My name is Iman Nasrallah, and along with my co-counsel, Nasrallah Mounzer, we represent Dr. Ward, the respondent in this case. Today, I'll speak to three essential elements impacting the application of the standard of care in the present case. First, the standard of care is one of reasonableness based on the medical practitioner's practice and experience. Second, the standard of care should not be based on results or goals. And third, an accurate assessment of the standard of care cannot involve hindsight. My co-counsel will address the second and third issues regarding circumstantial causation and non-negligent causes. The proper identification and application of the standard of care is a question of mixed fact and law. To determine if a trial judge properly characterized the standard of care, the standard of review is correctness, which the Court of Appeal correctly applied. The standard of care in medical negligence cases is clear and non-controversial. It is well established in the medical field that the standard of care is that of a reasonably competent practitioner in the relevant field. The principle underlying the standard of care analysis is that healthcare providers should practice in accordance with the conduct of a prudent and diligent practitioner of the same qualifications in the same circumstances. Every medical practitioner must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. This standard of care is outlined by the Court of Appeal in Kritz and Sylvester, which was also affirmed by the Supreme Court of Canada. The respondent urges this court to uphold the Court of Appeal's finding that the trial judge erred in defining the standard of care required by Dr. Ward. The trial judge made a series of compounding errors in coming to his decision. He combined the assessment of the standard of care issues with the causation analysis, which not only was an error, but it also allowed the trial judge to work backwards rather than to first define the standard of care, whether there was a breach, and then relate causation to that breach. The elements of negligence are necessarily sequential. A breach of the standard of care is a prerequisite to causation. The nature of the standard of care and causation inquiries, in particular, make this clear. The causation inquiry is not intended to answer everything that happened to bring about the injury. Rather, it focuses solely on the fault-based behavior of the particular defendant. Without first identifying a breach of the standard of care, it's not possible to determine causation because there's no fault-based act or omission to potentially link the injury. Based on the trial judge's finding, Dr. Ward was improperly held to a standard of perfection. Instead, the trial judge should have determined whether Dr. Ward performed the operation in a manner that a reasonably prudent surgeon would have done. The trial judge found that Dr. Ward took the necessary steps to identify and protect the ureter, which were the same steps that Dr. Armstrong's expert surgeon conceded a reasonably prudent surgeon would use. However, the trial judge did not identify any steps beyond those he found Dr. Ward to have taken to justify a breach in the standard of care. Courts have repeatedly recognized that practitioners have an obligation of means, not an obligation of results. This is a result of the nuanced nature of medical treatment. Medical innovation has granted society countless benefits, but these advancements come in tandem with certain risks. Every advance in technique is also accompanied by risks, and any person receiving treatment is subject to certain risks no matter what level of care is provided. As cited by the Supreme Court in Wilcox and Cavan, the doctor is not a guarantor of the operation which he performs or the attention he gives. Allowing the outcome to influence the standard of care risks distorting the standard, which ultimately may improperly reverse the burden of proof. Ms. Armstrong was aware of the risks inherent to a laparoscopic procedure, which are higher than those done by way of open surgery in certain elements. Regardless, Miss Armstrong accepted the risks in exchange for an advanced method of conducting her colectomy. It is therefore an error to hold a physician to the trial judge's standard, as no medical practitioner ensures achieving a perfect result. This rule was recently affirmed by the British Columbia Court of Appeal in Carlson and Sutherland, where the court overturned the trial judge's decision for imposing a standard of excellence that amounted to perfection, and subsequently setting a standard that was impossible to rebut. Similar to the present case, the trial judge improperly focused only on the result of the surgery and not on the precise manner in which Dr. Sutherland failed to meet the appropriate standard of care. As a result, the trial judge held Dr. Sutherland to a standard that amounted to a guarantee. Defining the standard of care by stating the goal does not inform the means through which a prudent surgeon would go about to achieve the required goal. In order for the trial judge's description and application of the requisite standard of care to apply, the trial judge would have had to distinguish the steps required from the steps Dr. Ward took. The trial judge, however, made no findings as to whether only negligent acts or omissions can lead the ligature within 2 millimeters from the ureter. Instead of asking whether Dr. Ward took the steps a reasonable, prudent surgeon would have taken, the trial judge measured Dr. Ward's negligence by determining whether he came within 2 millimeters of Miss Armstrong's ureter with the ligature. The correct course of action, as agreed upon by both Dr. Ward and his expert doctor, Dr. Hagen, who operate laparoscopically and have extensive experience using the ligature, is that the medical practitioner should intend to keep the ligature far away from the ureter. Instead, the standard of care suggested by the trial judge suggests that any deployment, whether intentional or accidental, breaches the standard of care. In reality, avoiding accidental deployment within 2 millimeters of the ureter cannot be fairly described as a step that a prudent surgeon would take. Instead, it's a goal to be pursued. In other words, trying to maintain a safe distance is a step that one takes. Successfully achieving it is a goal. The expert witnesses provided the trial judge with detailed evidence about the steps a prudent surgeon would take to identify and protect the ureter. The trial judge accepted the evidence and was satisfied that Dr. Ward took those steps during the laparoscopy to identify and protect the ureter. He explained those steps and testified that he always kept at least 5 centimeters from the ureter. Despite finding that Dr. Ward took steps of a reasonable, prudent surgeon, the trial judge predicated liability on the result. Precisely, Dr. Ward coming within 2 millimeters of the ureter. This evidence demonstrated that Dr. Ward carried out the surgery in accordance with a reasonable approach, so the trial judge turned to the result to find liability, which the Court of Appeal characterizes as an error. Had the trial judge properly applied the law to the facts he found, Dr. Ward would have been free from liability. Where the standard of care is informed by a goal of avoiding injury, the liability is heightened to one of strict or absolute liability, because logically speaking, liability follows with every injury in that case. Needless to say, this is an improper measure of liability in medical negligence cases. Courts have previously recognized that the law does not usually imply a warranty that a professional will achieve a desired result, but only a term that he or she will use a reasonable care and skill. Relying on causation to begin the analysis led the trial judge to reason based on hindsight and results, which allowed the trial judge to impose a much higher standard on Dr. Ward, the standard of perfection. Misadventure, however, is inevitable in the practice of medicine because of the reality that perfection in all cases is simply unachievable. For this reason, a core principle of professional negligence law is that one cannot reason backwards from an adverse outcome, implicitly assuming that if something went wrong, then someone must be to blame. In substance, the trial judge did exactly that, defining the requisite standard of care as not causing an adverse outcome. Instead, the correct approach is determining whether the surgeon acted reasonably in the technique employed in carrying out the surgery. In this case, identifying and protecting the ureter. This was not used to define the standard of care, nor to assess the breach. Where identification and protection were considered, the trial judge found that Dr. Ward met the standard. However, because the trial judge infused his definition of the standard of care with his determination as to what caused the injury, the trial judge still found a breach of the standard. The Court of Appeal correctly reversed this decision on the basis that the trial judge solely relied on the injury, which led him to determine the results based on improper reasoning. The trial affirmed, the court affirmed and established the medical negligence law that a trial judge must appropriately define the standard of care and identify the breach. In conclusion, the law on the standard of care required in medical contexts is clear and has been well defined for decades. Had the trial judge properly applied the law to the facts he found, Dr. Ward would have been free from liability. Subject to any questions, those are my submissions. My co-counsel will now address the issues of circumstantial causation and non-negligent causes.
Thank you, Ms. Nasrallah, for your submissions. You mentioned that the intention of the surgeon was relevant to the standard of care. Surely you're not meaning to say that there can only be a breach of the standard of care if the doctor intended to make harm. Just because someone intends to follow the steps that they're supposed to, if they can't properly execute it, then would that not also be a breach of the standard of care?
Of course, Your Honor. So intent in this context is the way that a surgeon goes about trying to achieve his goal. So in this case, it's the reasonable steps that Dr. Ward had taken to identify and protect the ureter. The intention, what I meant by intention is more so that during the course of the surgery, he was cautious to always protect and identify the ureter, which is the steps that he took to achieve the goal.
But he also said that he would have been 5 centimeters away from the ureter if he had taken those steps. And essentially what the trial judge has done is accepted that he was less than 5 centimeters and just decided not to agree with his evidence. Is this not more a matter of credibility?
In this case, the 5 centimeters is what Dr. Ward practices as his the precaution to take while conducting the surgery. So it's not always feasible for 5 centimeters to be kept away from the ureter, although it is the intention. And that is where intention is highlighted, that although the intent is to keep 5 centimeters away, it's not always feasible because of the nature of the surgery. But the trial judge highlights that coming within 2 millimeters of the ureter is what breached the standard of care. And this is what my client is rebutting, that the goal is to remain 2 millimeters away from the ureter. However, that cannot be the standard of care because there are steps in order to achieve that goal.
Thank you. I'll leave it to my other judges in case they have any other questions.
Sure. I have one question. So if the standards defined by the trial judge that, a reasonable surgeon would take care not to, would take care to protect the ureter, okay? And that was without looking at causation first. So he said, here's the standard, you have to take reasonable care, don't hurt the ureter or, try to protect it. And then looking at the facts of the case, and the severity of the injury to the ureter, applying those facts to the standard that has already been determined, and the trial judge says, listen, the severity of this injury is such that I don't believe reasonable steps could have been taken or maintained throughout the procedure. So I'm going to look at what happened, apply it to the standard that I've already set, and say, I don't think the standard reasonable care could have been taken. Is that a scenario that would be appropriate rather than the circular causation fallacy that you described? And how is that different than what happened here?
Your Honor, that is one step closer to what my client is suggesting and his expert evidence suggests. So in this case, yes, there are steps in order to ensure that a certain goal is attained. However, what you're mentioning is that if this goal is not attained, then one could look back in hindsight and try to work backwards and see what went wrong. And in this case, and specifically in medical negligence cases, this is a very risky exercise to go about because it's not just a black and white application. There are things that happen. There are risks inherent to medical procedures. And in this case, the doctor and his expert evidence and his expert surgeons, they all agreed on the steps that Dr. Ward took. So in this case, yes, there was an injury to the ureter. However, the standard of care that was provided by Dr. Ward was not breached due to this due to the injury.
Okay, thank you.
Thank you. Good morning, Justices. So as my co-counsel laid out, I will be discussing two issues today. I will first discuss when, if ever, causation can be used as circumstantial evidence to inform the standard of care. And then I'll move on to the question of whether the trial judge had an obligation to rule out non-negligent causes. And I'd like to begin by pointing out that these two arguments only flow if you accept the first argument, that the trial judge did work backwards from a results-based assessment, starting with the fact that an injury occurred and then arrived at the standard of care. So to the first issue, the appellant submits that causation can be used in exceptional cases as circumstantial evidence to assess whether there was a breach of the standard of care, but not to define the standard of care. The sequential negligence test that my co-counsel has already spoken to articulates the general rule that standard of care must be defined, a breach must be found before resolving causation. Now, the appellant does concede that there are exceptions, and in some cases, it is necessary to determine what happened in order to assess the standard of care. But this is an assessment of the breach, not an assessment of the definition of the standard of care. The Court of Appeal stated that where the nature of the injury is relevant to what happened, it's not an error to go about in applying the circumstantial evidence to whether there was a breach, but it is not relevant when we are defining the standard. Now, in Marangolo and Grass, there was in fact a need to determine what happened, but in both of these cases, the standard of care was defined before discussing causation. The causation, the what happened inquiry, was only used as circumstantial evidence to determine whether, based on the already identified standard of care, there was a breach. Now I'll take you through these two cases quickly. In Marangolo, the first step was to define that the standard of care in a bronchoscopy was monitoring the patient by satisfying three distinct requirements. The what happened inquiry was what caused the brain injury, and the circumstantial evidence that was led to satisfy this inquiry was looking at the defendant doctor's actions throughout the procedure to determine whether he actually monitored those oxygen levels according to the requirements, as well as other actions that might have caused this injury. And this was an appropriate use of causation and circumstantial evidence to inform that he did in fact breach the standard of care, but the standard of care had already been defined as monitoring according to 3 specific requirements. Similarly, in Grass, the standard of care was first defined as the doctor making a decision to transition from a vaginal delivery to a cesarean, and the risk that was to be avoided here was applying excessive pressure with the forceps to the newborn's head. The court found that circumstantial evidence was necessary, and it was used to assess whether the appropriate type of forceps and the amount of pressure used was in fact up to the standard of care. So again, having looked at, whether the appropriate type of forceps and the amount of pressure used would be determinative of whether there was a breach of the standard of care. Yet the plaintiffs were entitled to this because the standard of care had already been defined, and that was the judgment call that the doctor was making to transition. Now, the trial judge's error in conflating standard of care and causation flows from his incorrect application of the standard of care that my co-counsel has already spoken to. Now, because he worked backwards from a results-based assessment, the trial judge found the need to explore the what happened inquiry. And he used this to inform the standard of care to arrive at the definition that it was avoiding close proximity of 1 to 2 millimeters or direct contact with the ureter. And that's how he defined standard of care. So I'll take you through a quick analysis of the trial judge's, a quick summary of the trial judge's analysis. So his first conclusion was that the possible range of thermal spread by ligature is 1 to 2 millimeters, and the ureter would be injured if the ligature came within that range of thermal spread. He then reasoned that since the ureter was injured, Dr. Ward must have brought the ligature within 1 to 2 millimeters. He then concluded that the standard of care was to avoid close proximity of 1 to 2 millimeters or direct contact with the ureter, and this is the definition of the standard of care. By effect, injuring the ureter was a breach of the standard of care. Now, had he employed the correct standard of care analysis, he would have actually began at looking at what defines the standard of care. And that would have been expert evidence that was led. It would have been based on steps that a reasonable, prudent surgeon would have taken. And then when he got to the assessment of whether there was a breach, he could use circumstantial evidence as causation, which would amount to the actual events that transpired throughout the surgery, and it could be used to then inform whether there was a breach. So that concludes my submissions on the causation and standard of care. I'll move on to the issue of ruling out non-negligent causes. And again, this flows if you do accept the premise that the trial judge did reason backwards from a results-based assessment. So the majority in the Court of Appeal are not, as the respondents submit, creating or overturning an existing law by demanding that the trial judge does rule out these non-negligent causes. They are in fact simply clarifying the narrow circumstances where it can be permissible to inform standard of care by an injury. So our starting point would be the reason at paragraph 42 of the Court of Appeal. And the majority starts their discussion by saying that this does not have the effect of ruling out that there are in fact cases where negligence alone could prevent a goal from being achieved or a positive result from being attained. Rather, this is a limited exception where in some circumstances there are systems in place to prevent the injuries, and these systems are robust and established. It would not be harmless to define standard of care as a goal. For example, do not leave the sponge in the patient. Now, exploring what happened and how what happened might have been avoided in some circumstances is fine. But the issue is falling into the trap that it must have been negligence that brought us here without ruling out the non-negligent causes. And this might seem too abstract and demanding too much from the plaintiff, but it's not a matter of fishing outside of the records. It's in fact assessing whether the evidence on the record does satisfy it is sufficient that the only possible cause would have been a negligent slip. And again, we are limiting this inquiry to the cause of coming within 1 to 2 millimeters. Is it in fact only due to negligence? Possibly. So if we are defining the standard of care by the strict liability, then in every instance where the surgeon comes within 1 to 2 millimeters, this could only be due to a negligent slip and is an automatic breach of the standard of care. And if the trial judge, as he did, wants to define the standard of care as such, he must be able to make a finding that, and it is the plaintiff's obligation in this case to lead this evidence, that causing the injury could only be possible due to negligence. And again, this does not place an impossible burden on the plaintiff. They can always lead expert evidence to pinpoint whether there was an act or an omission that qualifies as negligent or not, rather than prove it in the alternative. Yeah, so in conclusion, in order to impose such a strict liability where the cause of the injury could only be negligence, the trial judge does have an obligation to be satisfied by the evidence on the record that this could only occur negligently, and the appellant submit that on this record, the evidence on that is insufficient. And that concludes my submission.
Thank you for your submissions, Ms. Mounzer. And maybe I have misunderstood the evidence, but my understanding was the plaintiff's expert evidence was that it was a breach of the standard of care if you came within 2 millimeters with the ligature, that was the breach. And so therefore, it would have been open to the defendants for their expert to respond to that and say, no, you can come within 2 millimeters with the ligature without it being negligent. To my understanding, that's not the evidence that was led, but if I misunderstood that, that's my apologies. But surely you're not going on then to say once the plaintiff has led expert evidence that says this is a breach, they have to rule out all other non-negligent causes. I mean, I'm sure if there was an earthquake or another natural disaster that caused the surgeon's hand to slip during the surgery so that he did get within 2 millimeters, the defendant would have pled that in their statement of defense or in their evidence. Is that not so?
Yes, thank you, Your Honor. So again, we are not fishing for every possible explanation that could be out there in terms of dexterity or a natural disaster that would have shaken the surgeon's hand, but it was on the evidence that is on the record. And as you said, the plaintiff's experts did lead evidence that it was a breach to come within 1 to 2 millimeters. And that's why at the outset, I did say that this flows, if you are accepting that it was incorrect for the trial judge to work backwards from that results-based assessment. And in fact, if he had gone through the correct standard of care assessment and defining and then only using causation to look at whether there was a breach of the standard, then this expert evidence would not hold. Because in fact, what we are submitting is that the 1 to 2 millimeters is not an appropriate definition to be placing on the standard of care, but rather it would have had to be the steps that were taken.
So it seems to me that you just disagree with that the trial judge accepted the plaintiff's evidence that a breach was if you were within 1 to 2 millimeters. Is it not just that the defendant put all of his eggs in the causation basket and spent all his time saying it wasn't a thermal injury, it was something else that caused the ureter injury?
Correct, yes. But it was, what we are submitting is that it is not the appellant's responsibility to bring forth all those possible non-negligent causes, but rather in making out the negligence case, which the plaintiffs are submitting that it was negligent to cause the injury, that because they are framing their case in this way, it was their obligation to bring forth that it was the only possible explanation.
Thank you.
All right, if there are no other questions from the bench, this concludes the matter of Armstrong and Ward. I invite everyone to remain for the following sessions. This courtroom will close, but there are 3 other courtrooms running. The next session starts at 1 o'clock. And then of course, we do have sessions running throughout the day tomorrow. So please consult the schedule that has been sent to all of you or the schedule on the Walker Health Law Moot website if you want to see other sessions running later today or tomorrow. Thank you.
Thank you.
Thank you, Jill.
Well done, everyone. Take care.
Thank you.
Thanks, everyone.